American corn is in crisis. Over the next 30 minutes, you'll learn how to join ADM, Cargill, and others who are seeking to recover lost corn income.
Hello, I'm Shad Olson along with Polly Meyer, and welcome to this very important broadcast about the future of American farming.
In any business, the bottom line is market demand. The value of a product is determined by how much product there is to sell and how many buyers are standing in line.
In recent years, we've seen a drop in U.S. corn prices of more than 50%, an understandably massive hit to the profitability of the family farm. You're about to get an in-depth look at one of the largest reasons for that collapse in price, traced back to the advent of a controversial corporate decision that has led to a decline of foreign interest in U.S. corn.
You'll also learn why farmers may be eligible for millions of dollars in compensation for lost corn income.
First, here's a quick timeline illustrating the market shift that we're talking about.
2009, seed corn giant Syngenta releases genetic trait MIR 162 into the American corn supply, originally marketed as Agrisure Viptera corn. In 2010, despite warning signs from major export markets, Syngenta pushes forward seeking approval for mass distribution, reassuring investors and farmers that Viptera corn will be accepted worldwide. 2011, Syngenta Seeds tries to silence their critics by suing Bunge Agribusiness for posting signs outside their terminals in an attempt to keep their shipments headed for China free of MIR 162. April 2012, the now infamous phone call with Syngenta executives as they issue definitive assurance that Viptera corn is ready for worldwide export, saying approval from China is expected within days. In reality, almost another 3 years passed before Chinese approval of Viptera corn. June 2013, 3 shipments of American corn are stalled in Macau Harbor near Hong Kong. Testing reveals the presence of the MIR 162 gene, and all 3 shipments are destroyed. Another 250 pounds of Viptera seed corn destroyed near Harbin, China. Hearing the news, a grain market analyst writes an article that circles the global trading community within hours, sending corn prices into a tailspin. By April 2014, 5 million tons of U.S. corn rejected or destroyed by Chinese ports, in all plummeting prices costing farmers an estimated $5 billion. Money now sought as damages by this legal action, money you and other corn producers are entitled to as a result of Syngenta corn's impact on the world market.
Of course, at the heart of the story are farm families just like you and yours, who've seen their profit and their ability to stay in business threatened by Syngenta. As you're about to see, a string of broken promises and negligence that have lowered the value of American corn by more than 50%.
Ben Beathy and his family have farmed around Tecumseh, Nebraska for over 100 years. Ben is not only a 4th-generation farmer, he is also representing local Nebraska farmers in this action.
I don't think that Nebraska farmers should have to pay for some big corporation's mistakes. If estimates are right, this is costing us between 22 cents to over $1 per bushel.
In farm country, we know that market price is the lifeblood of any operation. Any decline in price hits all of us directly in the pocketbook, affecting farm and ranch families, but also the businesses of friends and neighbors that keep small-town Main Street thriving and alive. People who've seen their businesses devastated by the collapse of American corn.
Our grains are break-even at best. Maybe a few of them are making a few cents, but especially some of our younger producers are struggling and maybe in the negative or in the red on their cash flows. So we're certainly having to buckle down with our customers and working with them, trying to figure out how to make those cash flows break even. And some of our younger producers, we're even doing some FHA guarantees to try to help do everything that we can to keep those guys in business.
Hi, I'm Ben Ennan. I'm an Iowa attorney and Iowa farmer. Farm with my father, Ron. I know another local farmer here that he had to send out letters to all of his landlords telling him he wasn't going to pay March 1st rent because his banker closed on his loan.
You know, everything's about business anymore. You know, farming's changed. Now it's all about the bottom line and dollars. Yeah, things have changed.
We don't want Syngenta to be able to get away with this, to be able to affect the market the way that they did, because if they can get away with it, every other company will. We're not litigious people. As farmers, we typically have taken the punches that the world's thrown at us, but Syngenta threw the first blow here. Bunge put up signs telling they weren't going to accept this corn, and Syngenta sued them for it.
Ladies and gentlemen, the stories that you've just heard show just how dire this situation is and how important it will be for the American corn community to speak with one very loud and very clear voice. Joining me now to continue this conversation are members of your local corn farming community. They are generational farmers. They also happen to be attorneys and lawyers interested in advocating for you in this fight. Let's talk about some very important case history that is related to similar damage settlements in other crops, specifically a case against Bayer Crop Sciences. And this was filed by rice farmers who suffered very similar damage in market value. Michael Watts, how did that case set the stage for this effort for corn farmers?
Sure. Bayer Crop Sciences did some testing on some genetically modified rice back in the 2005 timeframe. That rice, through drift, got out and infiltrated the entire United States rice population. As a result, all of the rice was in effect infected with this genetically modified trait that had not been approved by our export partners. It crashed the entire export market, and between 2005 and 2006, the income that American rice farmers were receiving for their crop crashed precipitously. And so we filed lawsuits on behalf of several thousand of those farmers against Bayer Crop Sciences. There was litigation in St. Louis, litigation in Arkansas. The farmers were successful in all 6 of the trials that were done, and that case ultimately settled for $750 million, which was a resounding success in getting the money back for the farmers. That laid precedent for what we're doing here with respect to the corn lawsuit against Syngenta.
In conversations with all of you off camera in preparation for this program today, you stressed to me that this is not about GMO technology, which has done so much to boost the overall harvest for the American corn farmer, but it's about business practice.
I have nothing against genetically modified products. As I like to joke with farmers, I ate 3 very large meals yesterday, and I'm sure that every one of them had genetically modified products in it, and I'm healthy as a horse today. The bottom line is genetically modified traits have been wonderful for the American corn farmer. We've gone from a country that produces an average of 80 or 90 bushels an acre to a country that's producing 150 bushels an acre on average. Up here in Minnesota and Iowa and Illinois, we're over 200 bushels an acre. Part of that's because of these genetically modified traits that are very effective in fighting off insects and corn borers and the like. This is not a lawsuit against genetically modified products. I'm in favor of them. This is a lawsuit about the realities of our world economic system, and that is that Syngenta knew that it needed to do one of 2 things. It either needed to get advanced approval from all of our trading partners, or it needed to be absolutely transparent with the American corn farmer, so that when that American corn farmer is making the decision whether to buy Syngenta seed or seed from somebody else, they know what the implications are. They were not given that information that they should have been given, and that's why we're bringing this claim.
It's now believed also that Syngenta executives knew implicitly that they were misleading the American corn economy about the nature of that relationship with China and what was happening in terms of the product approval.
Well, we're just beginning discovery in this case, but certainly the facts don't look good for Syngenta. First, the chief executive officer in an earnings call that took place on April the 18th of 2012 was asked, how am I going to buy this seed? You don't even have approval from China. And he said, we expect to have that approval in a matter of a couple of days. In truth, he did not have that approval. He wasn't about to get it, and he didn't get it for another 2.5 years until December the 16th of 2014. Archer Daniels Midland has filed a lawsuit, and in their lawsuit they have a screenshot from Syngenta's website, which purports to be the Chinese document, which is the approval of this MIR 162. We've since learned that that document is a forgery. When they're telling the seed salesman to tell people that there's no regulatory problem whatsoever, those facts do not bode well for Syngenta in this lawsuit.
Michael Watts, this question for you. We watched corn decline from $7 a bushel down to $3.50 and even below. Is that entire reduction in price, is Syngenta liable for that price drop?
Well, look, we know that the absolute drop in price was from $7 to $3.50. I'm not going to go in front of juries and say that Syngenta's conduct was the sole reason for that. Every farmer in America knows that we had a significant drought in 2012. We had bumper crops in 2013 and 14. But it gets back to basic laws of supply and demand. We're in a situation where the American corn farmer is so productive. Every American can't eat all the corn. Every American cow can't eat all the corn. Every American ethanol plant can't eat all the corn. We have an excess supply of corn. The only way that we're going to keep the prices up where they have to be for the American corn farmer to be able to afford to pay his bills is to have that demand equalized with supply. And the worst thing you can do in 2013 when you have a good supply year is do something that destroys the demand. I can't think of a better demand than 1.5 billion Chinese mouths. And the bottom line is that what Syngenta did destroyed the export market for the American corn farmer, and they exacerbated the separation between supply and demand, which is why the price dropped.
That's one thing we need to make very clear about this case. It is not limited just to the people who planted Syngenta product. No. This is about every corn farmer in the American market.
Sure. Every corn farmer in the United States was hurt when the price of the corn that they were receiving, which was $7 a bushel throughout 2012 and 2013, dropped to about $3.25 because of Syngenta's conduct, among other factors.
Ben Ennin from the state of Iowa, I know in conversations with you, you've talked about your neighbors and friends who've been so deeply impacted by this. That speaks directly to your heart, I know.
It does. I farm with on our family farm, but we've got neighbors that it's been tough seeing them go into the banks. The bankers are, I don't want to say rough because they're protecting their interest as well, but our incomes have went to half. You can't justify the farm loans that we may have taken out over the past couple of years, keep buying inputs at the levels that we're currently buying them at, and have the corn prices go to half.
Weather and grasshoppers, those are nobody's fault, but clearly that's not this case.
No, that's not this case. I mean, the bottom line is that Syngenta took a risk. They took a risk on the backs of the American corn farmer, and the risk blew up on them, but they didn't face the consequence. This should have never happened. What is right is to go forth into our constitutionally protected legal system and assert a just claim to get that compensation that was lost back, and more importantly, to keep them from ever doing it again. We can't afford for this to happen every third crop year. That's the kind of risk that we can't afford for companies to take on the back of the American corn farmer.
Is Syngenta going to go bankrupt over this situation?
No. Syngenta is the world's largest company that sells agricultural seed. They have a net worth of in excess of $32 billion. Most of these multinational conglomerates have insurance to cover things like this of well over €1 billion, which would be $1.4 billion. They have several $1 billion of cash on hand. Unfortunately, we're not their biggest problem, but we need to be a big enough problem to prevent this from ever happening again. It's not any farmer's goal to eliminate Syngenta, and frankly, we couldn't do it if we tried. The goal is to let Syngenta know that, hey, you can't take this kind of risk and engage in risky behavior on the back of the American corn farmer, because basically they said, look, let's get it out there, let's sell the seed, let's get that extra year of earnings in, and if it blows up, well, we'll deal with it then. The problem was that was a risky choice that they did on the back of the American corn farmer, and when it blew up in the wallet of the American corn farmer, not in Syngenta's wallet. So we're seeking compensation for the damage that we know that they caused, but we're not looking to get rid of what is a fine corporation with a lot of fine people working for it. The bottom line is that farmers want a world where they can buy seed from Dow, from DuPont, from Monsanto, from Bayer, and from Syngenta. And we look forward to a world where all of those companies are selling seed, but they're engaging in responsible conduct so that a corporate executive inside of Syngenta or anywhere else thinks twice before engaging in risky behavior that's going to blow up in the wallet of the American corn farmer.
Carol Hanks, besides being legal counsel in this case, you're also off a third-generation family farm in the state of Minnesota. You've been out in these communities listening to the stories of farmers who've been impacted right in their pocketbook by what we're talking about today. Can you share just one of those stories?
That's right, Shad. I actually grew up on a farm in southern Minnesota, and I still live in the rural community in southern Minnesota. I represent a lot of farmers in southern Minnesota. I have seen firsthand how this has, the last 2 years, have impacted their income, their livelihood, their family. We are interested in acting on behalf of our clients because we want to be their voice.
Go, Russ Ingebrigtsen, this question for you. With that Chinese ban of Viptera corn in 2013, what has been the direct impact in your mind on the American corn market?
Chad, the direct impact across the economy regionally and in the agricultural community has been devastating. It was predicted by agricultural economists associated with corn farmers' trade associations. Those economists predicted early on what the harm would be to the economy and to the interests of farmers and for everyone in the agricultural community in the chain of commerce.
You know, Chad, you mentioned that farmers work on handshake deals and honesty and integrity, and to be honest with you, this case, while it does deal with the golden rule, it really gets down to an issue of whether what Syngenta did was right or wrong. The fact of the matter is Syngenta had a choice. Of course they wanted to sell this seed, but they knew that that came with the risk. They could either delay it for a year until they got the approval that they knew that they needed. That's what the American Grain and Feed Association said that they should do. Do not prematurely commercialize this seed until you get that approval. But even if they didn't want to wait on China, they owed the American corn farmer the duty of honesty and disclosure. And when your chief executive officer tells the American economic world, we're going to have an approval in a matter of a couple of days, and you don't. When you put things on your website that purport to be a Chinese approval and they aren't. When you tell the Syngenta seed salesman, tell the farmer it's approved when it's not, you failed the basic test of right and wrong. And that's why this claim ought to be brought.
What's the total amount that we're talking about in terms of damages that are going to be sought in this legal action?
Well, before Syngenta even put this product on the market, they were warned not to do so by the American Grain and Feed Association that said in year one you could have damage caused up to $1.9 billion. In year two, damage up to $3.4 billion. Together, that's a lot of money right there. We think the numbers are a lot larger than that. The drop in prices was several dollars a bushel. Of course, we'll debate with Syngenta about what caused that drop, but the economic impact of what happened here is astronomical in the multiple billions of dollars. And as Russ said, it rippled throughout the Midwest economy from the standpoint of the guy that's selling the the equipment, the kid who's raising the cow at the 4-H that's not getting the donations that he got last year, the income that's not being spent on Main Street in all these small towns in Iowa, and Minnesota, and the Dakotas, and Illinois, Ohio, Indiana, throughout the Corn Belt. The bottom line is when farmers lose $5 billion, their neighbors lose many multiples of that.
Why should people join this specific legal action and not another one?
Well, I think that people should ask very good questions of their lawyers. Since November, our team has been out there conducting town hall meetings with farmers, asking them to ask us questions so that we can get what their concerns are. And the bottom line is that we represent more farmers who have filed suit by a factor of 5 than anybody else in America. We filed thousands of these lawsuits. We're way ahead of the game. We have experience from the standpoint of our involvement in the rice lawsuit. I could count on 2 hands the number of law firms that were working on that precedent-setting case. And because that was such a success, the joke is everybody with a bar card wants to be a corn farming lawyer now. But that kind of experience is important. And then in our industry, you have people that we call chicken catchers versus chicken fryers. And you want somebody that is comfortable in the courtroom. I tried a case last week in the state of Arizona. I'm in the courtroom all the time. The bottom line is you're going to want somebody that knows how to try these cases, that has experience with them, and that has filed enough of them that they've made that kind of substantial economic investment that you know that you're going with a team that is going to be first and foremost in Syngenta's mind when they're trying to resolve the case at the end of the litigation.
And not really only that, but the fact that we've got local attorneys on the ground. I'm one of them. There's several others throughout the state of Minnesota.
Illinois or Iowa, asking and working with you on a local basis. And I think that brings something unique to our group, that you have both the lead counsel with Michael and your local counsel who will help you with some of the discovery requests that we will have to have.
Not only that, it's important to point out for farmers from Minnesota that Syngenta is headquartered in Minnesota, and those farmers have access to Minnesota state courts in which local judges, local county juries, the peers of farmers, their neighbors, end up helping to resolve this case.
I think that's an important advantage that Minnesota farmers have. But the bottom line is having somebody who is highly respected by their neighbors, trying cases in their local communities with documents that show exactly what they were making before and what they were making afterwards, that puts Syngenta in a very difficult spot. A lot of these class actions get settled, and one of my big concerns about them is the lawyers run off with all the money and there's coupons involved and everything like that, and I'm not suggesting that would happen here, but the rules are different there. All they've got to do is place an ad in the paper 3 times, and so you see these really small size 8 font legal notices, usually on page D27 between the funny pages and the funeral announcements, and if somebody doesn't happen to see it and hire a lawyer to object to it, the settlement happens, and the next thing you know, you've got a settlement for a bag of seed.
Cargill, ADM, and Transcoastal, 3 other companies now suing Syngenta over that collapse and the lost corn income to farmers. How will that play into the final outcome?
I think the participation of Cargill and Archer Daniels Midland and Transcoastal Supply, these massive exporters of corn, is very helpful to the case. These judges know that Cargill and ADM have hundreds of lawyers, that they've got the world's best and highest renowned experts in the field of agricultural economics. They know that these major American agricultural institutions would have never put the brand of Cargill and ADM on this lawsuit unless this was a legitimate case with lots of merit, and of course it is. And so as we stand in hearings next to the lawyers for Cargill, next to the lawyers for Archer Daniels Midland, the credibility of this lawsuit from word go is clear to everybody involved.
So as you can see, this is a powerful opportunity for just compensation against a company which provably has damaged the price of American corn by as much as $1. Now we're going to go to the phone lines to get some of your questions about how you can get involved with this action. Caller, you're on the air with the experts from Lost Corn Income.
Hi, this is Fred from Marshall, Minnesota. If I sign up with you guys, how much is it going to cost me?
Ladies and gentlemen, what is the fee for becoming involved in this action?
The fee is only if we win do we get paid. The bottom line is that we're going to cover all of the expenses. In the rice lawsuit, we spent over $4 million. In this lawsuit, we'll spend over $10 million. But the farmer won't be responsible for that. And if we're not successful, if for some reason we stub our toe, the farmer will not get a bill from us. That's the risk that we take. However, if we are successful, for every $10 that we recover, the farmer will keep 6. We'll take the other 4 to repay the expenses, and whatever's left we'll split among the various law firms pursuant to the agreements that we have. But bottom line is it's a 60-40 deal. The farmer's going to get 60% of every dollar that's achieved in this settlement. When you hire a lawyer, the ability to put forth the millions of dollars it's going to take to finance a case against a $32 billion corporation is important, but I'm not looking for a pat on the back on it. It's a good investment of money for me. This is a case that I know from the Rice lawsuit has merit. It has legal precedence. It's easily explained. We know what Syngenta did wrong and when they did it and the damage that they caused. And it's my full expectation that the fee that we'll achieve on this 60-40 deal will more than cover the expenses, and it'll be a good risk.
Let's keep the phone calls flowing. Caller, you're on the air.
Hi, this is Art from Edford, South Dakota. How long is this going to take?
So there you have it. How long will this process take overall?
Well, the lawyer that knows when a case is going to settle when it's just beginning either has a better crystal ball than I do or is just a liar. But the bottom line is that I've been doing this for 25 years, and I started a lot of hair ago. But it gives me the experience to know certain factors. The first factor is who are the judges? We have a judge in Kansas City who's excellent, who has personally assured me that this is not going to be a situation where this becomes a litigation black hole. There's going to be a lot of cases up here in the Minneapolis area, which has a national reputation for excellent civil judges. So that will dictate in favor of this thing happening faster. It depends on who the lawyers are involved. I know that farmer that I'm being contracted to represent $10 to him is more valuable next year than it is in 2022. Well, so is my 40% fee on that $10. So we're in a hurry to get this done quicker as opposed to longer. But the real answer is Syngenta has to decide when it's in their best interest to try to resolve this.
So if I hear you correctly, the volume of plaintiffs in this case will actually go a long way toward forcing Syngenta's hand in coming to the settlement table.
Yeah, absolutely. I mean, the more dangerous the prospect of losing these cases is, and the number of plaintiffs that have filed suit puts pressure on Syngenta. And so there is strength in numbers. If only 2 corn farmers in America filed this suit, do you think Syngenta is going to be worried about it at all? No. The fact that 2,000 corn farmers have already filed suit and thousands more every month are filing suit creates litigation pressure that will make Syngenta really look in the mirror and evaluate its own conduct in a very deliberate fashion to say, hey, can I sell to a jury that what we did was the right thing? If they have even the smallest seed of doubt, and they should, then they're looking at having to sell that to jury after jury after jury with thousands of farmers waiting in line. And that is a recipe for Syngenta to come forward and try to do the right thing and to settle the case.
And we have time for just one more phone call. Caller, you're on the air right here on Lost Corn Income.
Hi, this is Leon from York, Nebraska. How much are the farmers going to make on this deal?
Now, someone with the bravery to ask the obvious question, how much would each farmer get?
Well, I mean, obviously that's going to depend on the success that we have in these bellwether trials. If we're successful as we were in rice, where, 3 cases are tried by good lawyers in St. Louis, 3 cases are tried by good lawyers in Arkansas, and the farmers win all 6 cases, that's going to give Syngenta a snapshot that we're not likely to win many of these cases. Well, the same thing goes from the question of how much will we get. If 6 different juries on average say, well, the price dropped from $7 to $3.50, but we attribute a third of that on Syngenta, $1 a bushel. And I'm using that not because it's too high or it's too low, it's a round number. The bottom line is that that would be the basis that we would utilize to settle the case. In the rice lawsuit, we were claiming that Bayer's conduct damaged 5 different crop years of rice. They were claiming it was only 1. Eventually, we got in and we haggled and negotiated, and they paid $120 an acre for year 1, $80 an acre for year 2, $60 an acre for year 3, $40 an acre for year 4, and $10 an acre for year 5, with a cap of $310 an acre. That $310 an acre was a direct result of what the juries told us they thought the value of the case should be. And so far be it from me before the first jury trial to predict what it is that's going to happen in these cases, but what I can tell you is a lot of the same experts are going to be involved, and we have a great deal of confidence that we will be able to demonstrate that first, Syngenta's conduct was unreasonable and caused the very damage that we're talking about. And then once the jury tells us what amount of that damage that they believe Syngenta caused to the American corn farmer, we'll be able to take that data and formulate a settlement program that properly compensates the farmer for what happened to them.
Ladies and gentlemen, I would submit to you that the passion that you've seen on display here, both for the plight of the American farmer and the compassion for each of those individual farmers on the part of our expert panel, those are very real. These are people just like you, and they're interested in partnering with you now and seeking justice in this landmark legal action.
I'm Polly Meyer.
And I'm Shad Olson. Thank you for watching this special report on the legal action against Syngenta for lost corn income. Your road to financial recovery begins today. To secure your claim and add your voice to the millions of farmers impacted by this crisis, call now toll-free 1-855-LOST-CORN or go to lostcornincome.com. Your decision today will help shape business practice for the next generation of American farmers.